I know we have a number of people who are attending breakfast meetings, so we expect the room to fill up a little bit more as we go along, but we are going to go ahead and get started if we could. Welcome to Day 2 of the National Lawyers Convention. I'm Dean Reuter of the Federalist Society, for those of you who don't know me. And I hope that those of you who joined us for the annual dinner last night had a wonderful time. And we certainly appreciate you, the stalwarts, I will call you, joining us early this morning at 9 a.m. That shows a lot of dedication. Last night, a lot of people in the room last night for our dinner, and wow, what a night, I thought. It's the night that I think will be remembered, the night that Justice Breyer spoke to us of rules and regulations, and also of the need for judicial independence, and received a standing ovation from the Federalist Society audience. I think it's also going to be remembered forever, actually, as the convention where Justice Gorsuch relayed key and complex legal lessons taken from the story of Peanut the squirrel. So I for one, did not miss too much the utter awesomeness and beauty of Union Station when it's lit up and so beautiful. I will note for the record that as a result of having the dinner in this room, we were able to host 450 more people than we could host at Union Station. I certainly did not miss getting to and from Union Station, especially in the rain. So just another show of hands, quick show of hands. How many of you missed walking through the rain to get to and from? Nobody's raising that. Oh, you missed. Ben Slivka from Seattle missed walking in the rain. We can't please everyone. And I did hear a couple people saying, well, there's so many people at the dinner, which reminds me, not of a story, but of a bumper sticker I saw once, and it said, "Stop complaining about the traffic. You are the traffic." I appreciate everyone bearing with us as we grow as an organization. We do have another great day of programming today, starting with this showcase panel addressing the question, how should law discourage tribalism, polarization, racism, racial enmity, and anti-Semitism in the United States? The people who titled this panel were challenging us to get that all on a placard. So I also want to briefly mention today's events before we begin. After this panel, we're excited to welcome in this same room U.S. Senator Eric Schmidt here in the center ballroom. We'll also have book signings today on the concourse and terrace levels, and please review your program for specifics on those book signings. After a number of breakout sessions this afternoon, we're going to finish the day with Jonathan Turley as he delivers the Olson Lecture. As I introduce this morning's panel, this first panel, I want to take an opportunity to thank all of our speakers, not just on this panel, but throughout the 3 days of the convention. And I particularly want to include my thanks to the speakers providing divergent views. I think it is our calling card here at the Federalist Society that we are able to provide debate and discussion on important legal topics of the moment and sometimes some evergreen topics. Of course, we're only able to have debate and discussion if we can get people of divergent views to join our convention. So my particular thanks and gratitude to those with divergent views that continue to show up at Federalist Society events. We couldn't stay true to our form without them. Our moderator for today's discussion is Judge Steve Menashe of the United States Court of Appeals, the Second Circuit. I will be very brief with his introduction because I've asked all our moderators to be brief with their introductions to panelists. Judge Menashe has served on the U.S. Court of Appeals since 2019. Previously, he served as Special Assistant and Associate Counsel to the President in the White House and as Acting General Counsel at the United States Department of Education. With that, Judge Menashe, the floor is yours.
Thanks very much, Dean, and welcome everybody to the, is there an echo or I'm just hearing that? So I don't know, somebody can. The reverb's still on from last night. I guess that's right. Is that better? All right, why don't I do that? Is there somebody who could adjust the echo?
I'm sure he's working on it. But
okay, fine. Yeah, that's fine. Okay. So thank you very much, Dean, and welcome everybody to our panel this morning. So James Madison famously said that the greatest security for our civil and religious rights consists in a multiplicity of interests and sects. In the extended Republic of the United States, among the great variety of interests, parties, and sects which it embraces, a coalition of a majority of the whole society could seldom take place on any other principle than those of justice and the general good. So the assumption seemed to be that Americans within our constitutional framework could look beyond deeply felt attachments toward the general good. But more recently, we've had the idea that some of these deeply felt attachments detract and inhibit the development of a common commitment to a general good. And despite an earlier sense that we're making progress against intergroup prejudices, there's a sense that those divisions are becoming more and more salient. And so our panel today is asking the question, what role have the law, the courts, and the culture played in contributing to this state of affairs, and how can law best be deployed to combat it? And what is the role of civil society versus the law in that effort? So to answer those questions, we have 4 distinguished panelists, and I'm going to introduce them in the order in which they're speaking. So we'll first hear from David Shizer, who's the Harvey Miller Professor of Law and Economics and the Dean Emeritus at Columbia Law School. He served as Dean of Columbia Law School from 2004 to 2014 and was the youngest dean in the history of the school. He is a co-chair of Columbia's Task Force on Antisemitism, which was created in the wake of the campus protests that involved hateful acts directed at Jews on campus in the wake of October 7th. Next, we'll hear from Jay Edelson, the founder and CEO of Edelson PC. He has been called a titan of the plaintiff's bar, and his firm is a leader in high-impact plaintiffs litigation. He has secured more than $45 billion in settlements and verdicts on behalf of classes, individuals, and government entities. He describes himself as part of the reform wing of the plaintiff's bar, which means that he is concerned about prioritizing the interests of clients over lawyers. Next, we'll hear from Matt Stoller, the Director of Research at the American Economic Liberties Project. He's a former policy advisor to the Senate Budget Committee and works in the House of Representatives on the Dodd-Frank Act. He's the author of Goliath, the 100-Year War Between Monopoly Power and Democracy, and he publishes a newsletter called Big, which concerns the history and politics of monopoly power, which you might be able to tell from the titles he is against. And finally, we'll hear from Michael McConnell, the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School, as well as a Senior Fellow at the Hoover Institution. He served as a judge on the U.S. Court of Appeals for the 10th Circuit and now teaches courses on constitutional law, constitutional history, the First Amendment, and interpretive theory. He's published widely, and his most recent book is Agreeing to Disagree, How the Establishment Clause Protects Religious Diversity and Freedom of Conscience. With that, let's turn to Professor Shizer.
Thank you, Judge, and thank you all. Is the sound okay? Good, okay. So sorry, I couldn't tell. Is it okay? No. Should I?
I don't know, I guess
I'll do this.
Use the podium.
Maybe we should all
So
just crack
it is a
that.
pleasure to be here with all of you. My thanks to my fellow panelists and to the Federalist Society for hosting this. When we talk about identity politics, when we talk about polarization, one of the places that is likely to come to mind is universities. So my job is to give you a case study about anti-Semitism at universities. I have an insider's perspective. As the judge said, I'm co-chair of Columbia's Task Force on Anti-Semitism. I should say that although what I'm going to say is specific to Columbia when I use anecdotes, my sense is that the dynamics, unfortunately, are familiar at a number of campuses, so I don't think that this is unique. I'm going to start by giving you just a quick sense of the problem and then some reflections on what to do about it. So in the last year, we've seen a level of hostility directed at some Israeli and Jewish students that I had not ever expected to see. And just to give you the flavor of it, I'm going to highlight 3 problems. And the first is the use of traditional ethnic slurs. I have a law student, who is taking my tax class last fall, and I was shocked to hear his experience. He was walking in the law school hallway when another student, not from the law school, but a Columbia student, came up to him and said, "F the Jews." He wears a kippah. I have another student who wears a kippah, spat on him at a protest. That sort of thing is happening, shockingly. Second are threats of violence, and I'll mention an incident that some of you may have heard about. There's a student leader who posted on social media a video where he was saying Zionists don't deserve to live, and the university is lucky that I'm not out there killing Zionists. So as bad as that was last year, it actually is worse in a way. Last spring, when that video went viral, the coalition of pro-Palestinian student groups apologized and distanced themselves from his remarks. But in October, the coalition apologized for apologizing. And they said that, quote, "We support liberation by any means necessary, including armed resistance." They said that no one should be cowed by the liberal or neoliberal media, as I think the term they used. So we have a group of students who are very proud of saying that Zionists don't deserve to live. In addition to slurs, in addition to threats of violence, there's also been a lot of exclusion from student groups. So you might have thought that these are groups that are about the Middle East, in which case one could understand maybe this is not a group that is a good fit for people who have a different view on those issues. But that's not it, not at all. I'm talking about theater productions. I'm talking about a dance team. I'm talking about volunteer activities in New York City schools. I have to say this reminds me of the way some conservative students have been treated over the years, sort of an exclusion and an isolation. It's very problematic. There's much more to say about this, but I want to turn to what to do about it. Before I do, I just want to offer two cautionary notes about what I just said. The first is things have in ways gotten better on campus. It's not nearly, there were very large, loud, disruptive protests almost every day for a while. This past semester it's been calmer that way, although still the rhetoric is more heated, as I mentioned. The other thing I want to say is that although I've reported some really unfortunate things that have been happening to Israeli and Jewish students, it does not define the totality of their experience. They're still getting a great education, they're making close friends, and really they know that the vast majority of people in the Columbia community are as disgusted by what they're experiencing as they are. We can talk more about that. But now let's think about what universities should do and what the government should do, what we all should do. So I'll start with values, and the first is obvious, it's education. A university's mission is to teach students to be guided by facts and analysis, not prejudice and slogans. We obviously need to do better at that. The second point is about civility. Conversations at universities should focus on ideas, not ad hominem attacks, and we need to model that more effectively. The third is a point about pluralism. We really have to stop classifying everyone in two categories, oppressor and oppressed. Not only is it inaccurate, but it also tends to drive people apart, and instead we should be focusing on respecting differences and on building bridges. Now, unfortunately, I think too many administrators and faculty across the country and at Columbia buy into this warring camps model, and frankly, this makes them part of the problem instead of being part of the solution. This problem was on full display at Columbia in an incident that some of you may know about. We had a reunion panel at the college last spring about the experience of Jewish and Israeli students, about what the university was doing to address these issues. And there were a number of senior administrators in the audience who were texting each other, and a graduate was sitting behind one of them, took pictures of their phone, and it turned out that the texts were making fun of the panelists and being completely dismissive of the problem. They were basically calling Jewish students a bunch of entitled whiners. And I'll just give you two of my favorites, if I can say that, of these texts. One was about students, quote, "It comes from such a place of privilege, hard to hear the woe is me." And the second, my particular favorite, "I'm going to throw up. It's amazing what money can do." So the bottom line is we really have to fix our culture, and we have to recommit to the right values. Part of that effort is to have better rules, so I want to turn to that. And there are three principles that I really think everyone should accept. And we wrote a report emphasizing these, and then there are a couple of specific recommendations I'll flag. These principles won't surprise you. The first is free speech rights. It's essential for everyone to be able to express their point of view. When we search for the truth, we have to follow ideas where they lead us. Universities should absolutely not empower administrators to decide what we can and can't say. But second, along with free speech rights, come free speech responsibilities. The fact that I'm speaking doesn't give me the right to drown out Jay from speaking, or if Steve is teaching a class, I can't disrupt the class because the students have a right to learn. So really I'm talking about time, place, and manner restrictions. They're critical, and universities are still struggling to find their way. The third point is anti-discrimination. We are supposed to be a welcoming place for all students. That should be a matter of values, of course, and it's also required under law, under Title VI, among other things. So let me finish with 3 specific recommendations. The first is no double standards. No double standards. Universities should not favor some protected classes over others. The same rules need to apply. So I'll give you an example, although I imagine you know what I mean. For many years, when universities decided whether a statement created a hostile environment, they were willing to accord a lot of deference to protected classes. So if a group said, this is making us uncomfortable, the university was responsive, and they tended to send the signal, you shouldn't say these things, you shouldn't do these things because it makes this group uncomfortable. But after October 7th, Jewish students expected the same treatment when they said, this protest is making us uncomfortable, this comment from a professor making us uncomfortable. But the reaction was very, very different. It was not, we defer to the protected class. It was, this is protected speech. Now, frankly, my view is that the argument your speech is making me uncomfortable is, well, it makes me uncomfortable. I think speech needs to be protected, and we shouldn't try to silence people just because we disagree with them. But what I will say is, I know that's a hard issue, not everyone agrees about it, but what we need to agree on is that whatever the rule is, however we decide to balance free speech and anti-discrimination, it has to be a uniform test. You can't have one practice for one group, another practice for another group. It's morally wrong, and also, frankly, it's pretty clearly a violation of Title VI. Second recommendation, it's obvious, but there's a lot to say about this, is just enforce your rules. A lot of universities, Columbia included, had pretty good rules. They needed to be better, but they were pretty good. But rules on the page, well, they don't do the job. They actually have to be enforced. And the third thing I'll mention is don't exclude people from student groups based on factors that are irrelevant to the student group. If you want to be in a dance team, the question ought to be, are you a good dancer? And the question should not be, what is your view about the war in Gaza? Because otherwise, universities are missing out on what I think has been one of their greatest strengths, which is to bring a community of people together who have different backgrounds and different views. And really, we're supposed to learn from each other. We're supposed to engage with each other. Ideally, we even befriend each other. But none of that can happen when you have to have 2 different dance groups, one for Zionists and one for other students. It's just unacceptable. So I know we'll have more to say about this, but let me stop there. Thanks.
Thanks. Thanks very much. Before we move to the next speaker, could I just ask this question, which is, your recommendations seem pretty straightforward, which is enforce the rules that the university already has and don't do it in a biased fashion. And so I guess I want to ask, why is it so difficult to get universities just to do that?
It is a real puzzle, and I will tell you there are 2 aspects to the answer. The first is there are a non-trivial number of people who sympathize with the protests to the point where they're actually trying to keep the university from enforcing rules. I think there's a bit of romanticization about protests, so wow, 1960s, I wasn't born yet, but that must have been great, that sort of thing. But there is another piece of it, which what I just said I'm sure is obvious. I don't think it's the predominant explanation. When you think about what happens at universities, don't start with conspiracy, start with incompetence. And so if you think about what disciplinary processes are needed at a university ordinarily, it might be that I got a little bit drunk and I broke Steve's computer and he's not happy about it, and I need to apologize and I need to replace it. And the bureaucracy knows how to do that. They know how to deal with plagiarism. But when it comes to, in effect, a culture war happening on campus, I think they were at a loss initially about what to do. And there's one more aspect about this, which is there is a received wisdom for decades that the right way to handle protests is to let them play out and to de-escalate. And I will say, I was a dean for 10 years. No one ever actually did try to take over my office, but my policy was, if you want to take over my office, tell me when you're coming, I will order you cookies. And you might say, why? And the real answer is because I had 2 offices. So do what you want. Trying to stop you might be more trouble than it was worth. But there was a fundamental difference, and the difference was the cost of that protest would be absorbed by me and by senior administrators. But what's different now is that the costs of the protests are falling on other students. These are effectively students not protesting the administration, protesting each other. And when you're in that position, you cannot be passive. You have to stop students from having these interactions with each other. And so just let it play out is the wrong advice, but it takes a while for people to see it.
Thanks very much. Jay?
Can I try it from here, or do I have to?
Yeah, I think it seems to be better now, right? Okay. we
People
can
can hear?
speak from here.
Terrific, because that was a long walk. So, so first, I appreciate being here. I think that it's probably good to give a little bit of context of why I am here, because it runs right into the other 2 points that I want to make. So I describe myself as an unentrenched left-of-center Democrat. Now, I don't know if anyone was paying attention, but there was an election fairly recently, and I've been watching kind of my. I don't want to say that they're clearly politically aligned with me, but they're certainly in the groups that I'm in. And what I've seen is that when I looked at the election, and there were a lot of identity types of arguments that were made, and I think then that it was rejected by the country overall. I've seen that my brethren on my side of the aisle have gotten the opposite message, which is to be further entrenched. When I think about my own kind of academic journey, when I went to law school at Michigan, the people I learned the most from were people who I didn't agree with at all. It was the very conservative professors, and I grew up in liberal Boston, went to school there as well, and I hadn't heard those views one bit. So it was really interesting, hearing things like transaction costs and how that actually can affect the real world. What I found was that the professors that I agreed with, I didn't learn a ton from. Maybe I felt a little bit better because someone was feeding back my own values at the time, but it wasn't a learning experience. And I found the same thing with my fellow classmates too. We had a lot of diversity of opinion. There were a lot of very liberal and very conservative classmates I went to school with, and I learned the most, frankly, from the discussion between them. This is where I think society and academia especially has gotten off track. As the professor said, much better than I could, the whole point of school, and especially when you get to a college or law school level, is to engage in big debates. That's why I'm here today, even during a potentially controversial time for a Democrat to be coming to FedSoc and speaking, and especially since I'm doing the unimaginable, which I am criticizing my own party. I do that not because I don't have criticisms of the other side, but I think that we live in a society where voices get drowned out if you're only supporting your side. And I think that's a mistake that fellow left-of-center people have made, where, for years, if something was on Fox News, we just assumed it was wrong. And we weren't willing to think about it. So I think it's really important that when you see your own people are maybe going in the wrong direction, that you speak out yourself. I think that you end up having a little bit more credibility. I don't want to put words in the professor's mouth, but I think, and I would assume he would agree with this. I think that this problem started a few years before the protesters. What started really bothering me was when very conservative, especially appellate judges, started going on law school campuses to speak about controversial issues, and the response from the left was not to engage them, but was to try to drown them out, yelling, booing, hissing, all of that. That to me was pretty unimaginable. If you have people who you might think that they're on the fringe, but they're federal appellate judges who are going to be making decisions that affect everybody, the idea that you wouldn't want to engage in debate with them is fairly crazy-making to me. Okay, with that as a background, I think one thing I can add specifically is the impact that I'm seeing on kind of this shift that's been going on for well over a decade of focusing more on identity than ideas, seeing how that has impacted in real life the court system. So I've got two examples of this. The first is there was a case in Washington. It was a personal injury case, and the plaintiff was a black woman, and there was a cross-examination where they attacked her credibility, and they suggested that she was making up her damages, that she was lazy, etc. The jury ended up ruling against her, and on appeal, the argument was that the questions that were asked during cross-examination were made to induce implicit bias in the jury. And the Supreme Court of Washington ended up accepting that and said the questions themselves on cross-examination can end up creating a mistrial. That, to me, first, I didn't understand that there was a trope about black women being lazy or making up damages. I was not aware of that. And I think it's really dangerous to start codifying in the law. These are stereotypes we have about different people, and we've got to protect against that. And it's, of course, insane to say just because of someone's identity, you cannot make certain arguments against their positions. I'm a plaintiff's lawyer. In every case, it is more than okay for the defense to say, your experts are stretching, your plaintiff is lying. They're allowed to say to me, you're greedy and you just care about money. And the idea that I would throw up like a Jewish defense, oh, Jews are considered greedy, so no one's ever allowed to criticize my fees, is just insane. Now, as I say it, I kind of think it does make sense, but Thank you. Thanks for laughing.
You've used that joke before.
Have I?
I don't know.
No.
You should use it again.
No, that was off the cuff.
That's good.
Matt, everything's off the cuff. No notes.
Okay, good.
So the other thing where I'm seeing this is kind of this identity way of looking things is, and I don't want to get too in the weeds, but I think it's important. In large plaintiffs' cases, often the courts have to decide who is going to be the lead attorneys. So you see these in class action cases and the large mass torts. It's really important who the courts appoint as lead because they're the ones who are steering the litigation, really on behalf of not just their specific clients, but on behalf of a lot of other people who aren't showing up specifically in court. The general rule is that the courts are fiduciaries, which doesn't quite make sense. I don't know how a court can be a fiduciary of a party, but they're supposed to have some sort of fiduciary duty to the people who can't actually speak for themselves. In choosing lead, you'd think that would be pretty easy. You'd pick the best lawyer possible. That's certainly what I would want. If someone's arguing on my behalf, I would like them to win. That would be a good thing. What the courts have started doing, not all courts, but a lot, have started saying, actually, there's some reasons we should engage in social engineering. There isn't enough diversity in the plaintiff's bar. So what we want to do is we want to start appointing broader teams of leadership and make sure that we all know the phrase that the team looks like the country. Now, I definitely agree that there's a problem in the plaintiffs' bar where people think the same, and I think that having differences of experience and ways of thinking is really important. The problem, though, of course, is when you start having these rules where you're picking people based on identity alone. My view is, beyond that, I don't think judges constitutionally can do that, but let's put that aside. The problem that you have is you're helping nobody. I'm sure there are a lot of big law people here, so apologies in advance, but big law is very good at hiring people for, what's known as the diversity track. So we will hire people, we will give them extra money to come to the firm, we'll pay off their loans, but then what happens is they're seen just by their identity, and they don't get the same amount of work, they don't get the same amount of mentorship. What you're seeing is, in the lead counsel world, you end up having firms put people up because of their identity, but they're lead in name only. They're not really the ones pushing the case. So I would argue it doesn't help the individuals. It doesn't really create more ideas, which is what you want. You want people to come forward with different approaches, and hopefully you figure out the best one. And of course, it doesn't serve the client's interests either. In terms of solutions, I think that's the hardest part. I think the solutions have to be that we've got to go back earlier in school, where we have to get rid of the oppressor-oppressed model. We have to get back to the idea that what makes America so special is the fact that, like here, we can engage in civilized debate. We can go back and forth, even though we have very different experiences and different political leanings, and hopefully learn from each other. But that's obviously an easy thing to say and a harder thing to pull off.
Thanks very much. Can I ask just this question, which is, since one of the questions before our panel is whether it's the culture or the law that's primary, it sounds kind of like the story you're telling is that there's this ideological attitude that we shouldn't hear from the other side, or we should repress divergent views, and then that attitude is kind of coming into legal doctrine and distorting it. Is that right? And then, if that's true, is there some kind of enforcement of the like some kind of legal, like something we could do in enforcing the doctrine to prevent those kinds of distortions, or to promote the kind of ideas you're talking about, or you think it's all in the realm of culture?
I think culture went first, and then the law picked up on it. That's my personal view. And especially with regard to identity issues. It's not just in terms of not having discourse, but it's the idea of we are going to make different rules for different people based on identity. In terms of is there a role for courts? Yes, there is. I think a lot of these issues are going to start going before federal appellate courts. I think that the Washington rule, which is a pro-plaintiff rule, it makes things really easy to win cases, by picking the right types of experts and all of that, is a really bad rule, and I think it's unconstitutional. I think the way courts are deciding lead is unconstitutional for reasons that we've seen in recent Supreme Court decisions. So, long answer, but yes, I think society came first, then law, and then law can fix that if we can find the cases that will end up in the appellate courts, which is hard to do.
All right, thanks very much. Matt.
Thank you so much for inviting me to this event. I always enjoy speaking at Federalist Society. There really is vibrant discourse and debate. But that is not why I came. I have some self-interest. So I'm a left-leaning Democrat, and I was promised by Alita that I'm going to get a nice prison cell. Access to the yard, maybe pudding for dinner. My side would not have been so nice. I see you applauding. So I'm going to try to take a step back and talk about, actually sort of jump off the judge's question about the roots of this. And I look at this problem of increased polarization as economic in nature. So I want to focus on, because I think, this country, if you look at intermarriage rates or any number of social statistics, we are far more tolerant as a people than we've pretty much ever been. And yet there's incredible polarization, far more polarization than I remember when I was young, and we were definitely much less tolerant then. I mean, just to give you a stat, Americans only approved of interracial marriage in 1995, right? And this is a very, very different country in terms of tolerance. So it's weird that we have this immense tension at the same time as we have, on a personal level, a lot more tolerance. And I want to focus on the tension between the traditional libertarian establishment, which I think is generally situated in the Republican Party, but has extensively in the Democrats as well. And what I think is happening with a sort of new populist approach, because that tension is foundational. The fundamental cause of polarization is, in my view, how we've handled our corporate apparatus. So core social infrastructure is now privately controlled and consolidated. And the ability of a small number of people to control that infrastructure means that political contestation has moved out of the realm of voting and law and towards cultural battles over the minds of otherwise unaccountable economic and political elites. So if you think about Madison, the judge talked about pluralism, lots of different interest groups, and that is traditionally understood as a political and cultural question. But as an anti-monopolist, I look at our commercial society, and that's how I think about competition. You need lots of different entities so that no one may control. Right now, we have a problem of dominance, and I'll give you a quick story that I think takes it out of the realm of the sort of identitarian arguments. In 2018, I was at a think tank called New America, and or maybe it was 2017, and European antitrust enforcers fined Google over a monopolization case. And we sent out a press release saying, that's good, we think Google is a monopoly. Eric Schmidt, who was then the CEO of Google, called up the head of our think tank and had us all removed, right? And said, because of what you said, you can't have a home here anymore. And it made the news. It was on the front page of the New York Times, and it kind of went around. And what was unusual about it wasn't that what was unusual about it wasn't that there was this cone of speech control. It was that someone had broken it, and that somebody explicitly said, we're going to get rid of you guys because of it. And because Google was funding almost everybody in town who worked on those issues. And that is when we talk about deplatforming, talk about debanking, a lot of the questions of how we manage identity and speech and polarization, we have to recognize that the social control over speech goes far beyond questions of identity. So with that, I'm going to read a couple of passages from Robin DiAngelo's book, White Fragility, Why It's So Hard for White People to Talk About Racism. That was a bestseller in 2018. I want to kind of bring us back to that moment. So, quote, stop using Caucasian as a euphemism for white. The term Caucasian was popularized by a white supremacist anthropologist from the 18th century, whom I will not reference by name. This overlapping, interconnected aspect of identity is called intersectionality. Some of our aspects of identity are more privileged aspects in society than others, but we are all a mix of both privileged identities and disadvantaged ones. An ally is someone who transfers their privilege to someone who lacks that privilege. When we are willing to take on the struggles of others as our own, we are practicing allyship. Allyship is like yoga. It's not a label, it's a practice. So I think we can all agree that these quotes are absurd, they're polarizing, and people who use them should be restrained by law from discriminating against Americans based on race, color, creed, sexual orientation, ideas, whatever. But I have a confession to make. I was actually lying. Those quotes don't come from DiAngelo's book. They are from the American Banker Association book, DEI Foundations, Practices for Accelerating Your Bank's DEI Journey. So, according to the ABA president at the time, DEI had been centered at every aspect of the organization. So banks, what does that mean? Banks are private entities that are chartered by the public, by the government, to serve as deposit-taking organizations. They have special privileges. That the ABA made a choice to allow for behavior that fosters important social choices that I imagine that conservatives find discriminatory is alarming. I mean, I'm a Democrat, I love that stuff, right? But you guys probably don't like it. Who doesn't love a good webinar? One might even say that these practices are unfair, and keep that word unfair in mind for a second, or for later. So banks and financial utilities have debanked based on political views. So in 2022, PayPal said, they started actually debiting user accounts, or said they would if they shared misinformation. And I think that kind of situation, like what Jay was talking about, frustrates everyone. Obviously, if you're someone who was, whose account was seized, you're unhappy. But is it really fun to sit there as a banker or PayPal executive and say, oh great, it's up to me to heal our divided country? Is that appropriate? Is that something they want to do? So what is a reasonable response to this kind of activity? Well, I would say it's public utility regulation, which has allowed for the setting of non-discriminatory rates and classes of service going back to medieval times, you know, among ferries, common carriers, hackmen, bakers, millers, wharfingers, innkeepers, and so forth. I don't actually know what a wharfinger is, but that was in Munville, Illinois. So property, this is from Munville, Illinois, 1877. Property does become clothed with a public interest when used in a manner to make it of public consequence and affect the community at large. When, therefore, one devotes its property to a use in which the public has an interest, he, in effect, grants to the public an interest in that use and must submit to be controlled by the public for the common good to the extent of the interest he has thus created. I don't think it's a coincidence that when we get rid of those kinds of that way of thinking, public utility rules, as we have since the late 1970s, that you see an increase of polarization. If it's okay for an airline or for Walmart to discriminate based on anything but identity, then you're going to see people claiming identity as a core part of their economic rights, even when they don't necessarily want to. But fortunately, we have, in terms of the debanking and Robin DiAngelo, not Robin DiAngelo, but you know what I mean, we had regulators who were interested in the problem. So the Consumer Financial Protection Bureau sought to get information about PayPal and its terms of service. It also revised its supervisory manual to ensure non-discrimination in all aspects of the offering or provision of consumer financial products or services, not just the provision of credit, but advertising, pricing, service, and collections, consumer reporting, payments, remittances, deposits, and algorithms. So they used not just their authority under the Equal Credit Opportunity Act, but also their authority under the law that allows them to ban unfair or abusive practices. And unfairness is a core term here because what Director Rohit Chopra was trying to do was apply traditional common carriage principles of law under the capacious term of unfairness. And I think we all agree that what those terms before that, those quotes, represented an unfair way to think about running a bank. But the ABA sued. And under the Major Questions Doctrine, CFPB was not allowed to update its supervisory manual. So the ABA is essentially saying bankers who control private infrastructure chartered by the public get to discriminate based on their social priorities, but the public cannot do so through its regulators. What's the, you know, that's just an invitation to harass bankers, to tell them, well, if you're going to make the social choices, we're going to harass you to make social choices that are in accordance with our values, right? Chopra actually was trying to do the banks a favor. If banks are not allowed to discriminate and regulators oversee that, then no matter how socially disfavored the client, no one can demand that they debank someone for cultural reasons. There will be no brand damage if you are not allowed by law to debank. Now, traditionally, discrimination, on economic grounds, mostly affects Black Americans, and it still does. So 2 days ago, the CFPB released the results of a secret shopper study. They sent 100 different people posing as small business entrepreneurs to banks in New Jersey and Virginia. Black entrepreneurs received substantially less encouragement to apply for a loan and were more frequently steered towards alternative loan products compared to white shoppers with similar or weaker business credit profiles. I don't think anybody in this room would see that situation as fair. And we all know there is a consensus that it's illegal to discriminate against people based on their race when it comes to credit choices, but it's still happening, as I noted. But it's almost certainly the case that it's not happening as much as it has. And I suspect, and this is the good news, one of the consequences is a depolarization of our politics. The glue holding together black voters, a fear of discrimination, is starting to dissipate, as we saw in this last election. And conservatives can accelerate that healthy trend by simply accepting that laws prohibiting discrimination are actually good for reducing tribalism. But this notion that it's a favor to bankers to regulate what they do, to take that power over social choices away from them, runs smack dab into the libertarian establishment. The traditional Reagan-era model was dominant, and still holds sway within the Republicans and still within some parts of the Democratic Party. Reagan-era conservatives believed that the threat to liberty came from government, that corporations were mechanisms for people to mass capital and productive capacity and then make something that's socially useful and profit. And core to our liberty as a society was ensuring that we would have restraints on government, but freedom of action for private entities. So there's a lot of legal manifestations of this. There's Citizens United, there's Trinco v. Verizon on antitrust, which said there's no duty to deal even if you're a monopolist. But over the last 7 years, there has been this new populism on the right and the left. People have noticed that dominant private firms who control key infrastructure are willing to use their power to censor or exclude. You have to get to the CEOs and harass them until they do it according to your priorities. And I think that polarizes our society, because then the question becomes, the fight over becomes who gets to speak, not what they say. It's particularly obvious after January 6th when Facebook, Twitter, Google, Amazon not only removed Donald Trump from their platforms, but targeted a broad swath of conservatives, including thousands of individuals. Social networking firms like Parler couldn't get a place to host their site. It's happening, still happening today. It happens to the left all the time. Well, people have realized that payment systems in banks target gun stores, data brokers, sell location about where social conservatives go to church. Firms like BlackRock force social policies on much of corporate America. And this is all under the protection of a kind of libertarian establishment, and it is deeply polarizing. So there is a new school of thought that is very critical. I think you're going to see a lot of those fights play out over the next 4 years. So here's Senator Josh Hawley in 2018 saying this model overlooked a core part of political economy. Right-wing politicians celebrated the private market no matter how corporatized or consolidated it became. The left, end quote, which he also believed that the left had this vaunted view of expertise, saw advantage in a kind of private version of socialism. But it is, as he put it, quote, a political economy of aristocracy. Now, the resurrection of political utility, of public utility law of Florida and Texas on speech in the Fifth Circuit decision on net choice in some of Clarence Thomas's writing on Section 230 is part of this dynamic. It's a recognition that there is a real problem here. But then you get into the question of the administrative state. And even if we move beyond conservative distrust of bureaucracies, there are legitimate reasons to fear regulation, even public utility regulation for non-discriminatory purposes, because even well-meaning regulators screw it up. There are other ways to get at it. It's, plaintiff's law. But that's where we get to the anti-monopoly element, which can actually make these regulatory choices easier. So one prong of unfairness is that consumers have no alternative. And in a consolidated economy, there's just less choice. Take banks. So in 1980, there were around 15,000 banks. Today, there are about 3,000 or so. And if you believe what Wall Street dealmakers are saying, that could shrink to a few hundred in the next few years. So a smaller number of people are going to be making decisions about the payment systems, about whether you can have a bank account or not. And each regulatory decision, by a public regulator or by a private regulator we call a banker, becomes that much more important culturally. Then there's, of course, social networking, search, Amazon smartphones, all of whom are very consolidated. When a magazine editor chooses to publish something, he is an editor. But if there were only one magazine in a society, that editor would become a censor. Similarly, today, because it's the only search engine, if Google decides that you're not going to see something, you won't see it because it's the only one. And if you're publishing something and Google says, I'm not going to put this out, you can't get your ideas to market. If there were 10 search engines, it wouldn't have that power. I look at what happened to us in 2017, 2018 as the downstream impact of that kind of power. It is inherent that the people running Google or Meta or Apple or BlackRock have immense cultural power. if we manage public utility rules for non-discrimination on those platforms, the regulators themselves will start to have some of that power. That's not necessarily what we want. We have to reduce the size and scale of these institutions through law so citizens have choice. And that would mean that there would be less of a need to group and polarize and engage in cultural shaming. We could just bank somewhere else or use a different search engine. And then we could actually live in a land of liberty, free of webinars.
Thanks very much. Your idea that you're doing the banks a favor if you take the identity politics off the table suggests that banks don't really, or the companies don't really want to engage in identity politics, but they're pressured by other clients. And so that suggests there's a separate ideological source of the idea, right? There's a traditional notion that universities were incubators of this idea that there's the oppressor or the oppressed, and so actually if you're neutral between them, you're really being oppressive, and so you have to be actively oppressive against regressive forces, and that idea went out into society and created this kind of pressure. So is your argument then that breaking up corporate power would prevent those kinds of ideas from propagating, or do you really think there's an economic source of them in the first place and that story is mistaken?
Sorry, can you sort of repeat that question? I want to make sure I understand exactly what you're saying.
Right, so I guess there's a story that there's an ideological idea, this oppressor-oppressed idea that requires the kind of censorship and so on that went out into society, and maybe that's the source of the pressure on companies to debank or to silence people and so on. And so when you're talking about, anti-monopoly, reducing corporate power, is the idea it's going to prevent those ideas from propagating, or do you think it does get at the source of polarization and the impulse? You see what I mean?
Yeah, I don't have a fully formed view on that, and it's frustrating because I wish I did. But I think a lot of this comes from the counterculture, there were some. I look at the law and economics movement as a cultural movement based in countercultural ideas. And, the traditional American law and culture, Anglo-American law and culture, the way we ran our society, even the idea of splitting the economy and culture is weird, right? And is I think, ideological. There were sort of two basic notions, and one was, that come out of the English Civil War, right? Too much concentrations of power is dangerous, whether that's in public or the private sector. And the other is we should try to reduce conflicts of interest if we can. No man may serve two masters, right? These were basic ideas. And we threw those out in the 1970s. And it was a left-wing movement that I think crafted the history that allowed that to happen. So this would be people like John Kenneth Galbraith and Richard Hofstadter and, there was that countercultural historian who wrote a motorcycle. I forget his name. He had a leather jacket. You'd know his name. He wrote but their basic argument was, America's always been capitalist. There've never really been any debates over our economy, over our culture. There's just kind of a sociological disagreement, status anxiety. That's what the populists were. And that was a very powerful way of saying the only thing that matters is efficiency. And I think Bork and a whole series of conservatives built and kind of operationalized that view, and which is why when in the late 1970s, early 80s, Bork wrote his The Antitrust Paradox in 1978, and I read the new version, I think a reprint of 1991 or 93, and he said, I thought this was a crisis in 1978, but we won almost immediately. And he was surprised at how quickly they won. And the decisions started coming out in the early 80s. But more than the decisions, there was just no pushback to it, right? So this was an ideological takeover of how we conceptualized America itself. We are no longer citizens with liberty and rights to property and rights not to be dominated by other people's property. Which is changed to consumers. And I think there's a kind of childish aspect to a lot of the cultural debates. But that aspect is how, consumers are supposed to, that's a consumer mindset. And so I think it was, I don't think you can separate ideology and law. Law is instrumentalized through ideology. Or sorry, one of the two. Yeah, sorry. So that's my answer to your question. I don't have a great, I don't have the example that sort of shows it. But there was this, it was very, very fundamental things about our notion of America coming out of academia, coming out of Columbia, were changing in the 1960s. And I think that was catalytic for the legal changes and the cultural changes we're seeing now. This kind of immense toleration. Like, personally, we're all so much more, I think I don't think anybody in this room would say, yeah, interracial marriage is bad, right? But that was like a common thing to think. And yet, there's so much more polarization. That is like a fundamentally weird dynamic. I don't think you can explain that by just saying, people are less tolerant today, because they're not.
Okay, thanks very much. Michael.
Thank you, Steve. So our topic is, how should the law discourage tribalism, polarization, racism, religious enmity, and anti-Semitism in the United States? Couldn't they have found a few other bad things that the law could discourage? I just wondering what this is about and trying to save time, I went to ChatGPT and entered our topic, and I recommend that you do it. It actually, I got a fairly lengthy little essay from ChatGPT with a number of concrete and very confident suggestions, proposals, recommendations, and I believe it is true that every single one of them would make polarization worse. And yet, I assume that whoever ChatGPT is a well-meaning, a person. But the moral that I get from this is, be very careful, because a lot of proposed solutions to problems of this sort are actually going to be counterproductive or perverse. So that's going to be my main theme. But I'd like to do just one preachy thing first before I do that, because I know, I've been part of these audiences from the very beginning. And when talking about things like tribalism and polarization and so forth, it is so easy to point the finger at the other side, the DEI people and this and that, the left, which is identitarian politics and all that, and not to notice the way in which those of us who are right of center contribute to the polarization. And yet, and I have to say, our president-elect, this is not exactly a depolarizing figure. And so I would just like to suggest to everyone in this room, and picking up really on something Jay said about the importance of criticizing one's own side, and I really appreciate that a bit of wisdom. Within the right of center world, let us try to be a force for decreasing polarization on our own side, and not be and not just complain about it when it comes from elsewhere. So, why am I up here? I feel like, who was that? Who was the vice presidential candidate Stockdale, who in the debate said, "Why am I here? Why am I here?" I assume it's because I know a little bit about constitutional law. That's, as far as I know, my only expertise. I am not an expert on cultural things, and this is, again, Jay said this is most of this polarization problem, is cultural. It's very deep, it's very hard, and if we expect the law to solve our problems, it's not going to work. Now, my main theme is going to be that the law actually is going to often makes things worse, and attempted solutions are often counterproductive. But in general, I just think, law is not going to be a major part of any of this. But that said, I'm up here with the pathetic lack of expertise that I have, but constitutional law, what does it say? And it does so happen that the framers of the United States Constitution were acutely aware of this very problem, right? They didn't call it polarization or tribalism. They didn't mention settler colonialism or DEI, but they were talking about the same problem. They called it the problem of faction. Judge Menashe began this panel by quoting from Federalist 51, and I think it's right on target. But in addition to that, they also understood that there was one particular source of polarization that they were especially acutely aware of, and that was religion. And so we actually have a clause, or maybe two clauses, or maybe three in the Constitution that were designed to reduce, among other purposes, of individual freedom and conscience and so forth. But in addition to that, there was a kind of structural, institutional decision that had to do with reducing religious polarization. So there could be no religious test oaths for public office. That reduces polarization because it means everybody's operating on the same equal playing field. The Establishment Clause, though, I think is the main locus of this, and Steve was kind enough to refer to the book that Nathan Chapman and I published a couple years ago, or last year, I guess, on how the Establishment Clause contributes to protecting religious pluralism. But here is the main message from the Establishment Clause, that it was important to keep the government from taking sides and from trying to impose uniformity. That's what the establishment of religion was all about. The leading statute that established religion in the British Empire was called the Uniformity Act. And we rejected that. Getting the government out, the government isn't going to tell us which religion is right. It's not going to play favorites among that's the essence of establishment. And let's see if we might apply the logic of the Establishment Clause to other issues, because we are polarized not just about religion, but about all these other things that are listed in the rather hilarious topic of this panel. And I think we could express the Establishment Clause in a modern term, which is, we now call it institutional neutrality. That's what the Establishment Clause is about. For the national government would be institutionally neutral. What an interesting and important idea. Universities are suddenly discovering it. And we can laugh because, why didn't institutional neutrality have anything to say when it was issues that right of center people cared about? Well, better late than never, I say, to universities waking up to the wisdom of this, and let's support it. Let's not just complain about the double standards. By the way, Dean Schizzer is very opposed to double standards. I think that could also be a bad thing, because it's often said in universities, if there weren't double standards, we wouldn't have any standards at all. So in any event, so universities are having a kind of Establishment Clause now for politics, and I'm struck by how much Matt Stoller's comments about banks. What he's really saying is banks should be institutionally neutral. They shouldn't be playing favorites either. It's not their business. They should just be banks, not trying to bring about uniformity with respect to political opinion. One of my hobby horses is the American Bar Association. I assume there are quite a few people in the audience who are influential, but it is wrong to say to me that I can't belong to the professional organization of my profession without having my dues used to promote a bunch of stuff that I don't agree with. The ABA ought to be like Matt Stoller's idea of banks. It ought to just stick to being a lawyers' professional association and not get into a bunch of things about which we may disagree. And let me say, I believe this just as much for things where I agree with the American Bar Association as where I disagree with them. They should just stay out of it. And I don't have a practical suggestion for the last thing, but the most important thing, the biggest Establishment Clause violation for politics. Establishment Clause, of course, doesn't apply to it, but using the wisdom of the Establishment Clause, the biggest problem is curriculum in the schools, because in too many places, our children are actually being actively taught to hate one another and to be polarized. And the schools are not practicing institutional neutrality with respect to curriculum. Now, I'm not quite sure that there is any sort of platonic ideal of neutrality, but I know non-neutrality when I see it, and there may be no more important thing for combating dangerous polarization than to reclaim the idea that public schools are for everybody, and they shouldn't be captured by, powerful political interests to use them to propagandize, to teach particular ideologies, especially the ideology that favors polarization. Now, I've probably talked long enough, but I wanted to say a few more things about the perverse consequences of some proposals for reform. And here I was going to turn to the issue of politics, because actually ChatGPT had quite a few suggestions along this score, and so they're on my list of perverse ideas. We've done a lot to try to improve the political system, and almost everything we've done makes it worse. And now there's some of these we're just not going to reverse. I think our reliance on political primaries to choose candidates has produced a great deal of polarization, because instead of the two parties competing for the middle and thus being moderating forces, as I think people like Edmund Burke believe that they would be, with the primary system drives the two political parties toward the extremes. I think that's quite unfortunate. I think the McGovern reforms, which were adopted by both political parties to choose to transfer power about the selection of presidential candidates from professional politicians to the people, has had the perverse effect of empowering demagogues and extremists, and that's not a good thing. I would love to return. I don't actually want the smoke-filled room, but something close to it. It would be good, and yet even the modest attempts of the Democratic Party through superdelegates to move back and a little bit the other direction have been, they're very unpopular. It's not going to work. Campaign finance has to be high on anybody's list of well-intentioned but mostly perverse consequences. By the way, ChatGPT does favor more campaign finance regulation. But here's what it does. We have limited the amount of money that people can contribute to candidates and to political parties. But we have, while leaving, and I think for constitutional reasons we have, leaving it okay to have private groups to make independent campaign expenditures. So what does this do? Both candidates and parties have reputations. They need to attract votes from the middle. They are the most responsible, I'm not saying they're real responsible, but the most responsible actors in the political scene. And we have a campaign finance so-called reform system which is designed to starve candidates, starve candidate parties, and empower outside groups. Some of those outside groups are special interest groups, which, some of them I like, some of them I don't like, but special interest groups, are a problem in general, right? And some of them are just sort of shadowy organizations in which, powerful influencers gather donor money and are inordinately influential in getting candidates and affecting the agendas of political candidates. It would be so much better if people like us could just give to the candidates and give to the political parties that don't have these problems. I think campaign finance reform has been a disaster from the point of view of actual reform. And I don't know how much time I have, but I was going to talk about jungle primaries and ranked choice voting, things that I thought were good ideas, and I think in principle seem as though they ought to reduce polarization. But together, the effect, now that we've seen the effect of these things, and they were especially important and seemed to be valuable. The logic of them seemed to be most powerful for one-party states like my own state of California, right? So Republicans, the minority, would be able to support the more conservative of the Democrats, and this gives Republicans some say and gives the Democrats an incentive to try to get support. It turns out that it doesn't work that way. And what it does do, though, is it eliminates the two-party system, because so often there's no Republican candidate for governor, there's no Republican candidate for Senate, and so it eliminates like 40% of the population from participating, right? And here's the point. I think that parties are actually part of the solution rather than primarily the problem, because what political parties are they assemble coalitions of competing interest groups, and all those competing groups within the party have to shave their demands a little bit in order to get support elsewhere, and the party cares about winning as opposed to any particular issue. And so in order to win, the political parties also have to appeal to the middle. And so the political parties are actually profoundly important institutions for creating responsible politics. And the jungle primary system destroys the minority party. And so instead of having, Republicans and Democrats sort of trying to come up with, platforms and so forth that are going to appeal to the people, you have the candidates all become entrepreneurs. They become loners, and the politics of that turns out to be heavily influenced by donors, heavily influenced by major single interest groups, and heavily influenced by demagoguery. And so I think this is an example of a reform, and I want to mention the fact that I thought this was a good idea just a few years ago, but I think the evidence is that it too is really has more perverse consequences than otherwise. So let's be careful about what we wish for in terms of using the law to combat polarization.
Thanks very much. So you said at one point it's better late than never that the institutions are discovering institutional neutrality. Maybe that's right, but is the fact that the universities were issuing statements about every political issue and worrying about harassment of every group until suddenly they were asked to condemn terrorism and protect Jewish students on campus, and suddenly they discovered the First Amendment institutional neutrality, does that mean that we shouldn't really trust that they've actually discovered it and that it's more opportunistic? What do we think about the actual development that they're now invoking this principle?
It really is disgusting, isn't it? That fighting terrorism turned out to be the one thing that universities would be neutral about. It's terrible and it's hypocritical, but if we didn't have hypocrisy to appeal to, what can we appeal to? I agree with you, they were probably not sincere, but once they have put their markers down and they realize that it's in the self-interest of universities to be neutral, let's hold them to it, right? Let's welcome the fact that they're adopting the Chicago principles and so forth. But it is our job to hold them to it. And next time they're about to, divest from oil because of their views on climate change, let's just say, you promised you weren't going to do this, and we're going to hold you to it.
Well, we'll see. Okay, I'm going to, in a minute, ask the panelists to start responding to each other, and I'll throw out some questions. But in the meantime, if you have a question, why don't you line up? Is there a microphone? I think there is in the center aisle. So why doesn't anybody with a question line up at the microphone? We'll start taking questions from there. And I'll just go down the line and sort of see if anybody has reactions to what the other panelists have said. I'm actually especially interested in, kind of obliquely, there's been references to anti-discrimination or civil rights law. A lot of people think that has created kind of the environment on campus, or kind of resurgence of identity politics, or it focuses on identity categories. But then it's also come up that maybe it's a solution, because there might be Title VI liability for universities that don't protect students from harassment and that kind of thing. And so maybe that's also not just constitutional questions, but that might also be about the role of law in making it worse or better. So why don't we just go down the line and see if people have comments.
So there's been so much interesting said, I'm trying to decide how to limit what I want to say, and I'll just keep it to a couple of points. One is institutional neutrality is something I generally support. There is an additional aspect to this, and it connects to civil rights law as well. So the Department of Education's position at the moment, when a state university says, well, people are saying these things, we know that it's creating a hostile environment, but it's protected speech, we assume it's okay, right? And the Department of Education has said, actually, no. And although you can't stop people from saying things, you yourself as an institution can condemn what's being said. And so that actually cuts against institutional neutrality, and the other option would be to try to be a bit more forceful in limiting speech. And maybe that's just my way of saying there are no easy answers here. I do think that in general what we ought to be doing is encouraging an exchange of ideas, encouraging it to be civil, though it won't always be, but we should be really careful about empowering university administrators to sort of tell us what we can and can't say. I will say, just in the realm of education, I'll offer one other thought, which is I'm surprised when people don't seem to see their interest. And so I do think, for those of us who are law professors in the room, there is an opportunity to try to steer students in the direction of advocacy, well, that actually works. And if you think about what the purpose of a protest is, if it's just to vent and to make yourself feel better, that's one thing. But if you're trying to actually persuade the other side of something, you need to know how they think about things. You need to realize that some ways in which you might make your argument are going to be so offensive that you will just lose any possibility of reaching them. And it isn't just at academic institutions. If you shut off the Golden Gate Bridge to protest a war thousands of miles away, are the people sitting in traffic saying, wow, yeah, no, they're right? I mean, it turns out that sometimes people are just acting in a self-destructive way, and if we all knew our interest and pursued it rationally, I think these conversations would feel different. And at least that's the way I think about the framers and what Madison was talking about with faction was rational engagement.
So two very quick points. One is I think that there are other ways to get at the issue legally. The universities have made promises to students, ironically, in their DEI language, which is we are going to create a safe environment for everybody. So if I have a private park and I say, come to the park, and the main thing is everyone's going to be safe, everyone's going to get along, but then I allow corners of the park to be, I don't know, calling for terrorist attacks against other people in the park, I haven't quite delivered the benefit of the bargain. And there's some interesting ways that regulators can go after this. The FTC, for example, could look at this issue under Section 5 of the FTC Act. One other very quick point, just because I think it's especially interesting. I also don't know ChatGPT personally, but I've had interactions with him. And I think it really goes to Matt's point, which is, Google as a monopoly has the ability to drown out voices. We know that. Generative AI, like ChatGPT, is that times 100, because instead of doing a search and you see all of these different pages of results, what ChatGPT does is it gives you one result. And ChatGPT does not have a philosophy it came up with. It was programmed to have a certain philosophy of the world. So what you see when you type in different questions, especially political or social questions, it has an ideology, and it's not very good at showing you a lot of different ideologies, because, as was said, it is a very confident being in this world.
One of the things about the discussion of universities, and I watched CNBC every morning, and for 3 months, every day, they were coming on and talking about what was going on at Columbia. And I was like, why does Columbia University matter so much? It's like one university, right? And some reporter went around to different state schools, and he found that nobody cared at any of the state schools about any of this stuff. And I'm like, okay, so is this problem really widespread, this polarization issue, or is it just happening at a few elite schools? And I think it's happening at a few elite schools. And why is there so much obsession with that? Well, I think there's a broader centralization of our society. So I'll give you two quick examples. One is, has anybody read JFK's essay when he was trying to get into Harvard? It's like, it's basically scrawled in crayon. And he's like, I think Harvard would be fun. I think it would be neat. And he got in, right? And it wasn't just because he was a Kennedy, that probably helped, but it was because they let in half of the people who applied, right? It was not a luxury brand. And in the 1960s, there were more committee chairs in the House of Representatives who were graduates of Cumberland Law School than Harvard Law. And Cumberland Law School, you did not need to go to college. It was a one-year training program. They were excellent. There were many of them who were excellent lawyers, but they didn't go through this elite path. In the New Deal, and then I think really up until the 1980s, the tension in law was mostly between regional lawyers and kind of big law. And a lot of that's gone away. The specialization of law is really now you're kind of centralized into these giant law firms, a very specialized niche. And that, I think, has created, I think one of the things that, I don't know if you guys saw Tyler Harper yesterday, he talked about the financial model of these universities. He said, look, this is a financial problem. These are luxury brands with hospital systems and hedge funds attached. And that's what they are. And I think you have to look at them like not as paragons of virtue and freedom. You have to look at them and say they're monopolizing hospital systems in New York, or they really care about private equity returns, like as opposed to truth. So my answer to this, and when somebody has to pay $60,000, $70,000, $80,000 to go to one of these schools, and when some of the professors don't have healthcare, you're talking about a very, very tense environment, right? As opposed to, it doesn't, you work a summer job and, you pay your tuition and there's lots of opportunities in academia. It's a much more relaxed environment. So my answer to the problem is not civil rights laws or anything. It's very simple. Just tax the endowments, right? Like just tax them, right? Hang on, you're not going to like what I say next. And fully fund state schools. Give them some competition, right? And there is this traditional tension. John Adams said a lot of things that I like, but he was basically pompous and annoying. And I think of him as the modern founder of academia because he was pompous and annoying and said, I don't like big money, but I also don't like democracy. Just listen to me. That was the gist of, that's a paraphrase. And that's my experience in academia. When I wrote a kind of a history, and I think with the experience that sort of fake amateur historians have when academics, it's like they're like, oh, this is surprising, it's interesting. That's really weird, right, that it didn't come from one of us. That is kind of the attitude in a lot of these places, and that happens because there's no competition. And these luxury brands are luxury brands, and they are just overcapitalized, and they're protecting their status. And I think we just have to say, let's overturn that hierarchy. Let's have a real democratic educational system, because the counter to the John Adams, who's sort of the founder of that, not the founder, but he was very important in terms of building that argument of kind of elitism in academia, was always what Lincoln did with the land-grant universities and saying, look, everybody should have education, funding, free public education for up through high school. You have to deliver more opportunities so that if you went to Harvard Law, like, good for you, I don't care. And then a lot of these, cultural contestations like become unimportant.
Michael?
I'd like to sort of applaud that, but I would like to note that there are a lot of private colleges that are not particularly elite and also are not infected with this. So just supporting public education may be not quite right. Tax the endowments, that's an interesting idea. I don't know exactly, but I want to throw another one on the table in a similar vein, which is, and this is actually a serious policy proposal that I think our newly elected Congress and newly chosen president might well get behind. So this is a serious political suggestion for those of you who have the ear of our governors. We should condition the acceptance of federal money by universities on not spending more than X% on administration. Now, my puckish tendencies say we ought to go back to, remember when TARP was passed, insurance companies got bailed out on the condition that they limit, I think the number was 20%. Insurance companies couldn't spend more than 20% on administration. I mean, if we did that to universities, that would be an earthquake. But why limit? It's not just that administrative bloat is one of the principal driving forces in increases in tuition and thus in making places like Stanford and Columbia unaffordable to people actually paying their own freight. But there's a more important development, which is I think the administrators are a source of a great deal of the mischief that goes on. At least at Stanford, who was it who was egging on those horrible people who treated Judge Duncan so terribly at Stanford Law School? It was our administrator who was supposedly there to improve, diversity and inclusion and so forth. And I think this is not unusual. I think if we would limit the amount of and you can't target this, right? It's just some state legislatures are trying to target it, and targeting it is very hard. But just limiting administrative bloat across the board seems like a good thing. Now, 5 years from now, I'll probably be on a panel saying, well, 5 years ago, I thought it would be a good idea. And we now know that had perverse consequences, but I can't think of a single perverse consequence of decreasing administrative overspending at universities. So,
Great, thank you. Let's go to the first question online there. We can't really hear. I think the microphone's not on.
Can you hear me now?
Yes, that's great.
There we go. Okay, thank you, panel. My name is Walter Clapp. I'm in from the wonderful state of Wyoming. And, part of what I want to direct us towards is a topic we didn't get to that I was hoping to get to in questions of law. I think most of the people in the room will agree that judges shouldn't make law under the Constitution. And if I think back to the subjects and objects of the Constitution authored by Professor Nick Rosencrantz, it's Congress that makes the law. And Mr. McConnell, I think you made an excellent point that we should be very cautious of the law that we might create, that it might be perverse. And you also pointed to the primary system as a potential source of polarization. But you didn't touch on Congress. And as I look riddled behind you at the silhouette of Madison, and I think of the papers he wrote on representation and the size of the House of Representatives that should be making our laws, and the immense polarization in that Congress, I wonder, Mr. McConnell, if you or any of the other panelists would agree that it is high time for us to consider expanding our House of Representatives as proposed in the First Amendment that was proposed in our Bill of Rights? And if not, why not?
I think this is a really interesting proposal. There is a serious proposal out there to increase the size of the House of Representatives, and it would be a way of especially empowering, smaller groups and so forth. I think there's a lot to be said for it. I think we could be confident that it would eliminate any possibility of the House of Representatives as a genuine deliberative body, because they may be too big to be a deliberative body already, and it does seem it's like one vote matters. It's it's the vote on the organization of the House at the beginning, and then the Speaker just runs everything. They might as well go home for all the deliberation they do, and that proposal would make that worse. But in the spirit of thinking about Congress and its dysfunctionality, let me throw out, I think there's a problem that might be solvable, and that is something that's sometimes called the Hastert rule, but it actually is a norm that's been around longer than Dennis Hastert, and that's that the Speaker will not allow votes, or I'm not sure exactly technically how this works procedurally, but basically won't allow the passage of legislation that does not command a majority of the majority party. And what this means is you can have legislation that would be supported by a huge majority of the Congress as a whole, putting together sum up the minority party plus a minority of the majority party can sometimes be a very large majority, and they can't pass legislation. And it does mean that both political parties are basically enthralled to their more extreme wings. And if it were possible to go across the aisle and pass things that way, I think it might decrease polarization a bit. And by the way, Mike Johnson did this on several occasions in the last Congress when he just couldn't get his caucus to agree to, like, you know, not send the nation into bankruptcy and that sort of controversial stuff. And I think maybe that would be a good legislative reform, even if we do keep the current size of the House of Representatives.
Can I just add one other institutional point about the House, which I think is familiar, but it's just worth observing? Gerrymandering also plays a role. What percentage of the seats are safe seats? A pretty high percentage. And when you are a representative from a safe seat, your biggest threat to your career is not losing to the other party, it's being challenged in a primary, and that tends to create more of an incentive to focus on your base than on the middle. And so again, the gerrymandering problem is very hard, and deciding whether there are any alternatives that might be better, that's not simple, and we're not going to talk about that today, but it is one other piece of this puzzle.
All right, let's go to this microphone over here.
Thank you and good morning. Sorry if I'm a little too close. My name's Chris Kenny. I'm from Delaware, a little bit away, not as far as most people, I think, that flew. I'm actually a public commissioner for the last several years of Middle States. So we have about 517 of the institutions so belovedly talked about today and yesterday. And my response is that I'm a public commissioner, and of the some 9 or 10 some odd accrediting agencies across the United States that have the strings on the Title IV funding that was discussed for a myriad of standard compliance issues, to include almost everything that was talked about. How many people can say in this room, non-academics, have actually applied to be a public commissioner and hold those strings?
Yeah, so that's interesting. So
That was it.
I take it the question is, you know, is there a role
Help,
for
help.
accreditors in enforcing standards on campus? Is that right? Or maybe people should get involved in that kind of thing. Is there,
Both. We can utilize the accrediting agencies to work in a more collaborative fashion to hopefully ameliorate these situations using the stick of Title IV.
Yeah, I
And
think we have
everybody's
that.
qualified to help as a public commissioner. There's nothing other than you're not an academic.
great. Do you have thoughts about the role of accreditation? I mean, there's a question about the ABA earlier, and the ABA acting as more than an advocacy group for lawyers, but they're also the accrediting body for law schools. I mean, would it help to have alternatives or to have different standards?
I mean, it's another example of institutions that are supposed to be neutral getting into controversial stuff. It's really quite terrible. And some of the accrediting agencies have behaved in a highly partisan and objectionable way, but it's one of those, like, they operate in the shadows. Nobody knows who they are. I didn't know you could apply to become a public commissioner. This is news to me. I don't know who these people are who are making these important decisions. I do remember that under I forget if it was first Bush or second Bush, but under one of the Bush administrations, the Department of Education actually intervened to prevent some of the accrediting agencies from doing strange things. I think one of the accrediting agencies was going to told a Jewish university that they couldn't have a requirement that there be a majority of Jews on the board of directors, which seems, I mean, that's basically to say you can't have a Jewish university, and that was one of the things that the Bush people, I think, were trying to crack down on. This really needs, first thing we need to do is know more about this. Somebody should really do some reporting so that we actually know what these accrediting agencies, who they are and what they're doing, because it all operates in the shadows.
Do you have a thought about accreditors?
So I think my thought is a lot like Michael's. I think in principle there could be a robust role for accreditation. My own experience as a law school dean suggested that a lot of aspects of accreditation for law schools turned into, pardon me, but interest group pressure from particular groups represented within the accreditation body who were then pushing schools to make pedagogical judgments that they weren't otherwise inclined to make. I will then just make a more general point, which is, and maybe I'm echoing some of the things Matt said before, I do think markets and competition are powerful here. Every school is competing for students with other schools. Schools are competing for faculty with other schools. Don't forget that schools are competing for donations with other causes. One of the things you're definitely seeing at a number of universities is that many donors have hung back and said, I really don't like what I'm seeing, you need to fix this, or you can't count on me anymore. And I think this is a long way of saying that universities have a strong interest in fixing themselves, and in a way they know better, the people who lead them have the more textured information about what to do, they just need to do it.
All right, let's go to this microphone here.
I'm Hans von Spakovsky, and Michael McConnell touched on this briefly, but Dean Schutzer, I was surprised when you said you were surprised by the anti-Semitism at Columbia. And the reason I say that, and you all really haven't spent a lot of time on this, is my friend Christian Adams and I did a 10-part series at PJ Media where we looked at the curriculums, the courses at the top 10 law schools as rated by U.S. News and World Report, and all the issues on your panel, tribalism, anti-Semitism, racism, those themes run throughout the frankly bizarre courses being taught at the law schools. And our conclusion was that the top law schools, the curriculums are so far to the left now that they seem to be geared towards wanting to turn out social justice warriors for the left as opposed to practical lawyers who can actually represent a client. Don't we have to fix that problem?
All right, so what about that? What about the curriculum?
So I think you can imagine that within faculties there are a range of views on that. I am certainly someone who believes that our primary mission is to train people to be terrific lawyers, leaders in the world, and what political causes they pursue, that's not necessarily something we should institutionally be trying to push. So I think I'm sympathetic to what you said. I will just say, empirically, I think our curriculum, there's so many courses. You can find a Federalist Society perspective in a number of areas. You will definitely find other perspectives in a number of areas. I think that kind of pluralism generally is healthy. But I think what I have seen in the last year and a half, and I'm not just talking about law schools, I'm talking more generally about universities, is that there's been a shift from a handful of people saying things that surprise me to large numbers of people saying things that surprise me. And therefore, I would say it has been different, but that's not to say that we've always been perfect, because no institution is perfect.
Can I?
Yeah, go ahead.
So I wish that what
You'll be next.
that what David Schutzer just said is true about their Federalist Society perspectives and so forth. But actually, our law schools are like monochromatic to the most, ideologically. I mean, the major law schools like Columbia and Stanford tend, they may have one or two. We just hired another. I won't mention his name because I don't want him to be persecuted. But we just hired somebody who's sort of a fellow traveler to the FedSoc Society. But it was the first time since I've been there 14 years, and the first time. So. As long as the law schools are so homogeneous ideologically, this solution of just having courses offered by, the different perspectives doesn't really work. And it really, I find it amazing. There is a huge body of research that shows that when you have a homogeneous decision-making body, that the results are not just sort of that median person. It actually drives the institution to extremes. The best research about this has been based upon 3-judge panels where you have, they're just a wonderful data set for proving this. But there's enormous evidence of this, and yet I don't see the researchers who produce this evidence pointing out that law school faculties are subject to exactly the same phenomenon. It is a scandal that law school faculties are as homogeneous as they are, and anybody who says that they are for diversity and inclusion should, the number one thing that they should be for is paying attention to some pluralism in faculties.
Jay, you wanted to say? Oh, go ahead.
Yeah, I just want to be careful that we're not being too narrow in terms of the prism that we're looking at this. I don't think that we should be just looking at this through the prism of anti-Semitism. Sure that's going on in campuses. I don't mean to wave my hand at that. That's obviously a bad thing. There's Islamophobia and racism and sexism. I think something deeper, though, is going on. And by the way, I think the last thing that Jews should do, and I'm saying this as a Jew, is to fight really hard so that we are now on the side of the oppressed instead of the oppressor. That is not a game anyone should be playing. And I think that really is the game of extreme DEI. If you really look at the movement of the protesters, it's not simply about Israel and Jews. It's about reframing the world into colonialists and I guess, native people, to the extent anyone could figure out who the first people were in any specific region. I mean, that hurts my head. But I think that is the larger agenda. If you really listen to the language, it is, the arguments against Israel as supposedly a settler country applies equally or more so to every country in the world. So that would be the one addition I would make.
Can I?
Go ahead.
So I'm not a lawyer, but I am a fake lawyer. And
Me too.
well, law school education is fundamentally weird because law school, as far as I can tell, teaches you to be confident when you say you're a lawyer, right? I mean, it's weird. You go to law school for 3 years, which didn't used to be a thing. Then you study for the bar. Then you go to a firm and learn how to be a lawyer. That's weird, right? I mean, if you want practical, if you look at it like plumbing and you say, go to a court and, argue and figure out how to convince a judge, which is how you actually learn how to do these things, then shouldn't we re-examine the premise that sitting in a classroom for 3 years, listening to people, and then studying for a different test, and then learning to actually do the thing that you went to law school for? Shouldn't we re-examine that whole premise? If you want people to be practical, cut it to a year. Want practical lawyers, cut it to a year. Eliminate the requirement to go to law school to become a lawyer. And honestly, there's a lot of bad lawyering at big law. From people went to fancy schools. There's not as much bad lawyering in the plaintiff's bar because if they don't win, they die.
That's 100% not true. Sorry, Matt.
All right, fine. Forget about my third solution. But I think there's
I want to hear it. I'm sorry.
Well, no, I was just going to say put more plaintiffs' lawyers as judges, because I think the judges are way too fancy. I think it's ridiculous.
That, of course, is true.
It's funny. When you say, one thing I disagree with, you say, I learn more from people I disagree with than people, I don't learn from people I agree with. And maybe it's because the people you agree with are dull and annoying. Because I learn a lot from them. But I will say, and I learned a lot from you, even though I agree with you on most things. I'll say, there's this notion that law schools are just run by the social justice left and the woke left. I look at that, and I'm a Brandeisian, and we have a specific view of antitrust law and competition policy. And people in the academy don't agree with us. It has nothing to do with sort of these social questions or DEI or anything like that. It has to do with traditional views of antitrust law, and you can say that we are wrong, you can say we are right, but you can't say that it's kind of outside the American tradition. But we still get the same arguments. This is woke, DEI, imposing, authoritarian views from social justice warrior stuff. And so I think you should just be aware that, don't fall into the trap of thinking that everybody is on the social justice warrior left within the university. Mostly academics in the university are they're like most people anywhere. They're just bureaucrats who are in a hierarchical system, and they are teaching mostly contracts law and torts and all the other stuff, and then a few of them teach weird stuff that can be kind of annoying. And they are trying to funnel their students into an excessively hierarchical, excessively centralized system. And that's kind of how you have to look at it if you're actually being intellectually honest.
Okay, maybe we have time.
Do you mind if I say one more thing?
So like a right of reply for
Okay.
law schools, I guess?
Yes.
Go ahead.
So look, I think Michael and I almost always agree, and I think I agree with a lot of what you said, Michael. And if the question that is posed to me is, would I like more members of the Federalist Society to be there with me on a faculty, then my answer is of course. But what I was actually trying to say is, you should not think of faculties as sort of members of the Federalist Society and social justice warriors. I think a lot of people in the audience know there's a whole range of different viewpoints, including people who are passionate about law and economics, but maybe aren't, have more liberal views on other issues. You have people who are focused on doctrine. So the sort of social justice activist wing of the faculty, it's there, but I think it would be a misdescription to say that it is sort of the entire faculty. It's just not.
Well, on that hopeful note, I'm going to make some announcements because we're coming to the end of our panel. What? Okay. So first, there are going to be book signings for A Life for Liberty by Randy Barnett and An Introduction to Constitutional Law by Randy Barnett and Josh Blackman up in the concourse level right after this program. And the next piece of programming will be a fireside chat with Senator Eric Schmidt in this room at 11:15. With that, please join me in thanking our panel. Thanks very much.